Great. Thank you so much, Danielle, and welcome everyone. Welcome to actually the title has changed since we talked, but System Update Required, Managing Risk in the AI Era. And we'll just jump right into it. This program has been, actually, I probably don't need to do this because you've already said that it was certified for um, credits. So let's just go through that any time we can gather. So the educational activity will support your ability to describe current trends, legislation, and emerging models shaping AI use in healthcare, with emphasis on federal and state and regulatory requirements and disclosure requirements, excuse me. Recognize legal, ethical, and patient safety risks associated with AI-enabled tools, such as ambient listening, chatbots, and algorithmic decision support, particularly regarding informed consent, privacy, and bias. Apply best practices for disclosure, documentation, and clinician oversight and to mitigate liability and promote responsible patient-centered care. Right. The information that is contained in the presentation is intended as risk management advice. It doesn't constitute a legal opinion, nor is it a substitute for legal advice. So any legal inquiries about topics that are discussed this afternoon should be directed to an attorney. So before we get too deep into the implications of AI in healthcare, we're going to briefly discuss what AI is in general and the history of its development. It's important to distinguish between common AI related terms. AI is a broad umbrella concept. Artificial intelligence, AI, simulates human intelligence through the use of software designed to think and act like humans, displaying capabilities such as learning and problem solving. The first AI program was developed, believe it or not, in 1955, marking the beginning of various specialized fields under the AI umbrella. Machine learning refers to systems that improve performance through experience with data, and deep learning is a subset of machine learning that uses layered neural networks. And I know this is complicated stuff, but and is often used in imaging and speech recognition. Generative AI, excuse me, represents the newer category. And this is where systems are capable of creating new text, images, audio, and video rather than just simply what it was going when happened prior. Over the next decade, the healthcare AI market is projected by some to approach $500 billion in size. With that level of investment, we can expect that there will be an accelerated technological development and increasing rapid implementation across clinical, administrative, and operational settings, further amplifying both the opportunities and the risks that are associated with AI adoption. So next, let's briefly review the current regulatory landscape and how AI is governed and overseen. The current healthcare AI governance ecosystem remains fragmented, and it probably will for a while, and it's multi-layered. Oversight is spread across a combination of federal agency regulations, state laws, executive actions, and professional organizational guidance. Taken together, this ecosystem reflects a rapidly evolving but still disjointed approach to governing healthcare AI. And it's one that requires healthcare organizations to navigate overlapping legal requirements, policy signals, and professional expectations rather than relying on a single unified regulatory framework. So, though there has yet to be a large-scale federal legislation on AI, 2025 did see a handful of executive orders aimed at the issue, and many states are also pursuing legislation. So while there's no single comprehensive federal statute that directly governs the use of AI in healthcare, meaningful though fragmented um, oversight exists above several federal agencies. For instance, the FDA regulates certain AI tools as medical device, and that's abbreviated SAMD, to ensure that they perform as intended and don't pose unreasonable risks to patients. To fall within the FDA's jurisdiction, the software must be intended for one or more medical purposes and perform those purposes independently of a hardware medical device. Many healthcare AI tools meet this definition and are therefore subject to FDA regulatory requirements. By contrast, some AI tools don't meet this definition. For example, AI functionalities embedded within an EMR that are primarily designed to store, organize, or display health information rather than to independently diagnose, treat, or directly drive clinical decision making. The Department of Health and Human Services enforces HIPAA, which governs the use and protection of protected health information. DHHS also oversees civil rights laws that prohibit discrimination in federally funded healthcare programs, including discrimination that may result from the use of AI tools. Both of these areas will be addressed in greater detail later in this presentation. And then finally, the FTC, the Federal Trade Commission, has the authority to pursue enforcement actions against companies that might make false or misleading claims about their AI products. And this includes misrepresenting AI systems capabilities, performance, clinical benefits, etc. So as you can see, it's multi-layered and there are a bunch of agencies that are involved. So we'll go through them. Some of the most consequential and rapidly developing regulations are occurring at the state level, addressing key risk areas. And those include areas such as transparency, bias, accountability, and patient protections. State level developments may help demonstrate both the direction in which AI governance is evolving and the practical compliance challenges faced by healthcare organizations operating across multi-states. And I think that probably would be something that you will be interested in going forward. The AMA, or the American Medical Association, has taken an active and sustained role in shaping policy guidance on the use of artificial intelligence in healthcare, with a consistent focus on patient safety, physician accountability, and ethical innovation. Central to the AMA's efforts is the concept of augmented intelligence, emphasizing that AI should support but not replace physician decision making. The AMA adopted its first AI-related policy in 2019 and has continually expanded its policy portfolio on the topic. And in 2023, the AMA Board of Trustees approved a set of core principles for AI. So AMA policies don't carry the force of law and they're not legally binding. However, they can have meaningful persuasive value in legal and regulatory contexts. Courts and litigants may look to the AMA policies as evidence of professional norms, emerging standards, or ethical expectations, particularly in areas where formal legal guidance is limited or developing. While a physician can't be held liable solely for failing to follow AMA policy, such guidance may influence how a jury or court evaluates reasonableness of a provider's conduct, especially in informed consent or standard of care disputes. So, excuse me, as a result, AMA policies are best understood as influential professional guidance that can shape legal narratives and risk management expectations, instead of enforceable legal requirements. Now we're going to jump into the current state of healthcare AI. AI has infiltrated, the medical industry. As of 2024, North America maintained a 54% share, a global share of the healthcare AI market. and it's expected to grow exponentially each year. As of September 2025, spending reached 1.4 billion, tripling from 2024. That's incredible. With health systems in front at 27% adoption, followed by outpatient at 18% and payers at 14%. Healthcare AI companies are focusing on medical record documents and revenue cycle management. In 2025, ambient scribes garnered the most attention and revenue creation compared to other clinical AI solutions. And that certainly marries what I see when we take phone calls daily. And when it comes to AI issues that are we're getting questioned about, it's truly been the ambient listening, which has been the biggest. These solutions present lower risk to patient care and generate organizational assurance with turnkey, swift production. We can also expect to see a boom of healthcare access and remote features, placing AI in the hands of the consumer. That should be interesting. These tools will be marketed as lifestyle monitoring, vitals tracking, triage for urgent and emergency care scheduling, and care follow-up communication. We're no longer knocking on the door of AI solutions in healthcare because the door is wide open. As of September 2025, more than 70% of healthcare organizations around the globe were utilizing clinical decision support systems generated by AI. Faced with high demand coupled with physician attrition and burnout, health systems are leaning heavily into AI solutions. 65% of hospitals use AI predictive models, with 92% of utilization directed at inpatient trajectory prediction, which I figured out means the old flow in hospitals, followed by high-risk outpatient identification and scheduling. Results are promising. Within pilot programs, unplanned ICU transfers have been cut by 20 to 30%, and patient wait times for imaging have been reduced by 15 to 25%. Machine learning AI is particularly well suited for analyzing large, diverse data sets, especially in applications that require image interpretation. While radiology accounts for nearly 75% of FDA authorizations for AI-enabled medical devices, cardiology represents the second most active area of FDA submissions, excuse me. In cardiology, AI has been cleared or proposed for use in applications such as ECG analysis, arrhythmia detection, echocardiography, and patient risk stratification. Radiology dominates the AI market of solutions authorized for purchase, making up 76% of FDA's AI medical device approvals from the 1990s through mid-2024. 80% of radiologists believe that AI will support their work in the field while not replacing it. Recently, the FDA cleared an AI CVD, which takes routine cardiac and lung CT scans and screens for 11 latent issues associated with cardiovascular disease. The new screens allow for subsequent proactive monitoring or treatment of risks and conditions that would have potentially been missed, such as heart failure, AFib, fatty liver, visceral fat, stroke, calcification, and osteoporosis. Without adding tasks for the medical staff, this AI algorithm creates a bridge from existing diagnostic scans to meaningful preventive medicine. And that's pretty neat. On a June 2025 study by the researchers at Northwestern University examined generative AI-assisted radiograph reporting, or the process, which is the process of interpreting an X-ray image and drafting a corresponding text report. The generative AI model was integrated into the live clinical setting, the first tool of its kind to do so. It reviewed almost 12,000 X-ray interpretations, focusing on documentation efficiency, accuracy, textual quality of the reports, and diagnosis of unexpected pneumothorax, requiring additional clinical intervention. Because it can cross-check imaging with the patient record, new or urgent conditions may be red flagged earlier. With the model producing the first draft report, radiologists' time dedicated to documentation went down by a mean of 29.4 seconds, which I know it doesn't sound like much, but when it's aggregated, it certainly means something. It shows showing its 15.5% efficiency increase per study. So there you go. Change in clinical accuracy or textual report quality by radiologists remain the same with or without AI. Over 97,000 X-rays were assessed for pneumothorax diagnosis and were swiftly and accurately identified. The study suggests that this generative AI may provide radiologists with increased documentation efficiency, saving time without compromising clinical accuracy. Based on these results, the time savings represented a decrease from 79 to 67 radiologists shifts for equivalent interpretation and report coverage. This AI support will prove meaningful as the demand for radiology needs increases with a shortage of specialists. So 15 months had passed since that earlier study, and the more recent responses remained relatively static with only a few areas showing meaningful change. Though there was only a 5% increase of physicians feeling more excited than concerned about the growth of AI, the use of AI skyrocketed from 38% in 2023 to 66% in 2024. Interestingly, 54% of physicians showed some level of not being entirely sure if their practice actually used AI for non-clinical purposes, and 41% were unsure regarding use of AI clinically in their workplace. Whether in a hospital or private practice, physicians really should and must stay informed about how AI may be factoring into billing, coding, and prior authorizations, um, patient monitoring, or diagnostics, or other parts of the clinical workflow. In late 2024, considering the growing prevalence of AI, the AMA conducted a repeat survey of over 1,100 physicians to gauge their feelings on AI utilization. A combination of primary care physicians and specialists, as well as physician practice owners and employed physicians, participated. This study questioned the physicians' interest for AI use in their own practice settings. Interest in AI jumped slightly in most categories, with general documentation, note and care plan generation, and chart summaries rounding out the top three use cases physicians are most excited about. When gauging the largest area for AI opportunity, physicians overwhelmingly pointed to AI addressing administrative burdens through automation. Surveyed physicians indicated their foremost regulatory priority is to increase trust in AI through increased oversight of AI devices by governing bodies. Throughout this presentation, you'll hear from attorney Scott Salter, a partner at Starnes Davis and Flory LLP. Scott regularly defends physicians in medical professional liability cases and closely monitors the evolving use of AI in healthcare. In this clip, he discusses the growing deployment of predictive AI tools in hospital settings, particularly systems designed to flag patients um, at increased risk for conditions such as sepsis. And he offers his perspective on how this may impact that setting. So here's Scott.
For a hospital in implementing AI, it is important for them on the front end to validate the artificial intelligence program they're going to use. That may include discussing with the manufacturer what the data input is, discussing what the algorithms are that are going to be used, and also discussing
Sorry, I was changing the
effectiveness of the program for patients. Many of these programs that are being used by hospitals they are looking at the efficiencies that it may provide to the hospital. But they cannot forget they have to look at the program as well from the effectiveness it may have for the patients and how it will affect patient care. How does it impact patient care? And so I think that's something the hospitals have to be conscious of. I would say from a physician standpoint right now, the biggest area that they have to be thinking about from a liability standpoint is when they disagree with the screening tool that the hospital may have in place. And to give an example, hospitals now have artificial intelligence programs that are scanning the medical records of all the patients in the hospital. They are looking for signs or symptoms that may predispose that patient to a specific medical problem like sepsis. Then when you have that artificial intelligence product and it trips that sepsis screen, and when the physician's called, the artificial intelligence product says this patient may be predisposed essentially to sepsis. The physician's going to have to make a decision. Do I treat this patient for sepsis? Or can I look at this patient and say, I'm not going to treat this patient for sepsis, and the reasons why are the patient really is not septic. They're not at a point that they need to have treatment. A physician has to be ready to either take that, potential diagnosis, act on it, and document why they are taking that action. Or if they disagree with it, if they think the patient is not septic or predisposed to sepsis, that they don't need to be on an antibiotic or to be monitored in a different way, that they can state in the record why they are disagreeing with that screen by the artificial intelligence and what their rationale is.
So when patients are discharged from the hospital, they're handed what often feels like reams of paperwork containing various clinical summaries, instructions, and education. Comprehension of these documents can be overwhelming, especially especially for individuals with low health literacy, and for their provision loses the intended purpose. A study published by various departments at Duke University in 2025 reviewed the efficiency of the Generative Pre-trained Transformer 4, better known as GPT-4, an AI application that translates inpatient discharge summary notes into plain language. The analysis reviewed plain language, easy for me to say, um, translation by GPT-4 for four common discharge diagnoses: acute ischemic stroke, diabetic ketoacidosis, community-acquired pneumonia, and congestive heart failure. It then measured 553 patients' subjective and objective comprehension and their confidence level after reading two translated summaries, as compared to reading two original untranslated summaries. For each of the four conditions, the translation substantially improved patient comprehension. And that again is pretty cool. So as you can see, artificial intelligence has already had a significant impact on healthcare. However, its most immediate and visible effects, experienced by both patients and providers, are occurring in the area of ambient listening. For many physicians, this is the primary point of contact for them. So let's talk about that. Ambient listening AI systems are growing rapidly in popularity. According to a 2024 MGMA survey, 42% of medical groups are already using this tech. These systems use room microphones or cell phones to record physician-patient conversations, then generate suggested notes and billing codes. The provider reviews and finalizes the note and then adds it to the medical record. The appeal of the technology from an efficiency perspective is apparent. A 2025 study published by the Future Healthcare Journal found that clinicians spent approximately 2.5 hours fewer hours per week on after hours documentation, a reduction that correlated with lower levels of frustration and burnout. Also, a 2025 study published by the Journal of the American Medical Association, excuse me, reported a decrease in burnout rates among ambulatory clinicians from 51.9% to 38.8% following implementation of ambient documentation tools. As is the case with almost every new piece of new technology, promised advancements bring with it new risks to account for it. So let's talk about those. One significant risk associated with the use of AI in healthcare is automation bias. And that's the tendency for individuals to over-rely on automated systems, even when those systems may be incorrect or incomplete. A commonly cited example, and I'm sure one that you can relate to, is the overdependence on GPS navigation, where users follow automated navigation directions despite clear real-world cues to the contrary, such as posted road closure signs or visible hazards. And my particular favorite is when the Siri or the voice is telling you to take a right and you're going south on Route 1 and it's the ocean on the right. So, anyway, those are some examples. Automation bias has the potential to permeate nearly every application of AI in healthcare, particularly as these tools become more accurate, efficient, and seamlessly integrated into clinical workflows. As clinicians grow accustomed to AI-assisted outputs, there is a risk that critical oversight and independent clinical judgment, may gradually erode. Another issue to consider is an ambient AI's exposure to legal discovery. While clinicians are typically only privy to AI-generated notes, ambient listening systems may also capture and store a raw audio recording of the entire patient encounter. Whether this data is retained depends on the design and configuration of the specific system. As such, physicians and practices must work with their vendors to determine whether their chosen system stores complete audio recordings. If a system retains raw recording of the patient-physician interaction, it will undoubtedly be discoverable in litigation. In a worst case scenario, there could be an inconsistency between the note in the medical record and the audio recording. So even a seemingly minor inconsistency could undermine the accuracy and reliability of the entire medical record. It may also suggest that the physician engaged in automation bias and failed to adequately review the AI-generated notes. Negative optics of this nature can derail an otherwise really defensible case. Another issue that must be accounted for is potential spoliation of evidence. Now, because these audio recordings are generally discoverable, you have an obligation to retain them in certain situations. This duty to preserve begins when litigation is reasonably anticipated, pending, or ongoing. And failure to retain these recordings can lead to allegations of spoliation of evidence, which can result in legal sanctions or adverse inferences. And adverse inferences can have a catastrophic consequence in litigation. Essentially, it allows a judge or jury to assume that missing, destroyed, or withheld evidence would have been unfavorable to the party responsible for its absence. In other words, when a party fails to preserve or produce evidence it had a duty to maintain, the fact finder may infer that the evidence would have harmed that party's case. Don't feel like inviting anyone in. Patient disclosure and consent is another essential component of utilizing ambient AI. Ambient AI tools typically support documentation workflow or quality improvement rather than directly delivering medical treatment. As a result, their use usually does not trigger the same informed consent requirements as procedures. Ethically, however, it is still justified by principles of transparency, respect for persons, privacy, and trust. Patients that have a reasonable expectation to know when their conversations are being recorded, transcribed, or analyzed by AI. Consent can be obtained either in writing or verbally, and according to a 2025 study published in the Journal of the American Medical Association, verbal consent was the most common approach to obtaining consent. This same study found that nearly every patient wanted to know more about the AI system's data use, data storage, and how audio was used and transmitted, and who had access to the recordings. During the consent process, providers should be prepared to provide answers to all of the questions that are posed. Posting notices like the one you see here on the screen in exam rooms where ambient listening is available is also a really good idea. Wiretapping laws are another reason to consent must be considered when utilizing ambient listening AI. Under federal law, a recording is generally legal as long as at least one person participating in the conversation is aware of the conversation. Is aware of the recording and consents to it. This is known as one-party consent. In addition to being the federal rule, a majority of states also adhere to one-party consent, the one-party consent standard. On the flip side, there are a handful of states, including California, Florida, Illinois, Pennsylvania, Washington, and Oregon, that require two-party consent or all-party consent before a conversation can be legally recorded. These rules extend to conversations captured by AI during patient exams. The best course of action, regardless of your jurisdictions regarding consent standard, and I think for most of us in the room, it's two-party consent, is to obtain consent from all those who will participate in the conversation captured by AI. A lawsuit filed in California in November of 2025 is one of the first examples of litigation linked to ambient listening AI. Using an ambient listening AI tool without the patient's knowledge or consent. According to the complaint, the tool recorded entire exam room conversations, including sensitive medical and personal information, which was then transmitted to the vendor servers for processing and potential review. It also claimed patients were never informed their visits were being recorded, nor given the opportunity to consent or opt out, despite California being a two-party consent state for confidential communications. The lawsuit further alleges that the AI system automatically inserted false consent language into the medical record, stating patients had been advised of the recording and had consented, even when no such discussion had occurred. The plaintiff argues that this practice violated California's privacy laws and the Confidentiality of Medical Information Act, or CMIA, which requires written authorization before sharing identifiable medical information with third parties. Ambient listening is likely here to stay, so with it comes some best practices that should be implemented, Be transparent with patients. Clearly disclose the use of ambient listening or AI documentation tools at or before the point of care using plain language that explains what the technology does, what information is captured, and how it supports clinical care. And be sure to obtain consent before initiating the recording conversation. Even if patients have previously agreed to the use of the system, letting them know at each time the AI system is activated and deactivated will go a long way towards putting them at ease with the technology. Allow patients to opt out. Provide patients with a meaningful, easy to exercise opt out option that doesn't delay or compromise care, and ensure clinicians and staff are trained on how to honor that choice in real time. Understand and manage data retention. So that means fully understand your vendor's recording, transcription, and data retention practices, including how long audio and derived data are stored, who can access them, and how and when they will be securely deleted in accordance with contractual obligations and requirements. If you, your practice, or your organization is exploring the use of ambient I encourage you to listen to our podcast episode on this topic. Um, in the episode, the CFO of a multi-state healthcare organization shares practical information, knowledge, and insights on how their team approached the deployment of ambient AI, how the technology has been received by both the patients and the clinicians, and the operational compliance and workflow considerations that they encountered along the way. And you can actually just use the QR code uh, to listen to it. Sorry about that. I jumped along. But when you get the slides, you should be able to use the QR code if you're interested. While there is general consensus that the use of ambient listening AI should be disclosed to patients, disclosure and consent can become complex when AI is deployed in less visible ways that nevertheless influence clinical care. AI tools may operate in the background, supporting diagnosis, risk stratification, treatment recommendations, or documentation without any obvious patient-facing interactions. This raises a critical question. How should clinicians approach disclosure and consent when AI meaningful, excuse me, when AI meaningfully informs care, but it's not directly experienced by the patient? Many of the legal and ethical questions in this area remain unsolved and untested, and standards continue to evolve across jurisdictions, professional organizations, and regulatory bodies. That said, there is a clear and growing push toward greater transparency driven by patient expectations, emerging guidance, and risk management considerations. So, this next section explores how disclosure and consent principles may apply across different AI cases and where clinicians should be aware of what's going on. When we talk about patient permission around AI, it helps to separate informed disclosure from informed consent. Informed consent is the more formal doctrine tied to agreement to the medical intervention, typically requiring discussion of the material risks, benefits, and alternatives, so a patient can decide whether or not to proceed. Many U.S. jurisdictions frame material information through a reasonable patient lens. That is, what a reasonable patient would want to know to make a decision. Informed disclosure, by contrast, is the broader transparency obligation, telling patients truthfully and plainly that AI is being used, what role it plays, and um, whether there are and what guardrails exist without necessarily running a full procedure style consent every time the tool is used. This distinction matters because most AI deployments in healthcare are support tools, documentation, workflow automation, population health flags, administrative prior auth assistance, or clinician-facing clinical decision support. Where the clinician remains the decision maker and AI is not it's in and of itself the treatment. In those common scenarios, full informed consent is usually not required, but transparent disclosure is still appropriate. Down the road, we will assuredly begin to see AI implementation that directly involves diagnosis and treatment decision, which may necessitate, a formal informed consent process. Regardless of how it's framed, disclosure of informed consent or informed consent, patients increasingly view the use of AI in their care as a material concern. A 2023 Pew Research Survey study found that approximately 60% of Americans reported discomfort with their healthcare provider relying on AI. The AMA's policy H4.809.931, which is assessing the intersection between artificial intelligence and healthcare, recognizes that transparency and disclosure obligations related to AI should not be a one-size-fits-all. The policy expressly states that decisions regarding transparency and disclosure should be guided by a risk and impact-based approach, taking into account the specific AI use case and its potential effects on patient care. Importantly, the AMA emphasizes that the obligation to disclose increases as the risk of patient harm associated with AI-enabled technology increases, underscoring the need for heightened transparency when AI meaningfully influences clinical outcomes. So the more AI is used in clinical outcomes determination, the more important consent becomes. AI systems are inherently complex and in many cases continuously learning. And this complexity is a key reason they hold such promise in healthcare. But it also introduces new and very unfamiliar challenges. One such concern is called the black box problem, which refers to the reality that an AI system's internal reasoning process is not often fully visible or easily explainable, even to its developers, which is kind of weird. This lack of transparency has important implications. From a legal standpoint, it may create evidentiary challenges in the event of litigation, an issue we will address, I'll address a little later. More fundamentally, it raises a critical informed disclosure and informed consent question. Can a physician adequately inform a patient about the risks and benefits of AI-supported care if the physician cannot fully articulate how the AI system reaches its conclusions? A compelling argument can be made that the physician need not understand the technological intricacies of of an AI system, but instead should be prepared to provide a general explanation of the system, the role it plays in clinical decision making, and its limitations and risks. One proposed approach to addressing the black box concern in the development and deployment of explainable AI or XAI is XAI systems that are designed from the outset with interpretability and transparency in mind, allowing clinicians and other stakeholders to better understand and evaluate how AI generated outputs are produced. So I know very complicated stuff, but I think, the more you learn it, the less complicated it becomes. From a risk management perspective, the most prudent approach is to err on the side of transparency and disclose the use of AI whenever it plays a role in patient care. To ensure disclosure is meaningful, providers should be able to, at the very least, describe at a basic level how the AI functions, the role it plays in clinical decision making, and its known limitations. As AI becomes more deeply embedded in clinical and administrative workflows, it raises a series of interrelated legal questions. Does the use of AI increase a provider's exposure, or conversely, could failure to adopt AI create a risk as the technology becomes more prevalent? How will courts evaluate claims involving AI-assisted decision making? And perhaps most importantly, will AI meaningfully alter the standard of care? At present, many of these issues remain unsettled. Case law is limited, regulatory frameworks continue to evolve, and courts are only beginning to confront AI-related claims. That said, examining existing liability theories and early litigation trends, we can begin to anticipate how AI is likely to influence medical malpractice claims, evidentiary disputes, expert testimony, and overall litigation strategies going forward. As healthcare AI is increasingly deployed across both clinical and administrative settings, it's important to recognize that we have not yet seen a significant volume of litigation directly focused at AI-driven medical care. Much of the current discussion reflects projected liability theories grounded in existing legal frameworks, rather than a well-developed body of AI-specific case law. That said, as AI adoption expands, courts are likely going to be asked to apply traditional theories of liability to AI-related claims, adapting established doctrines as these cases begin to work their way through the legal system. In the following clip, Scott Salter highlights a few of the theories of legal liability that that exist now.
I think what we're going to see are theories that can range from a true argument for a medical malpractice claim made by the plaintiff, arguing that the decision making was faulty and that they can be held liable just like a physician. There can be other theories, such as a true product liability theory, that the design or implementation of the algorithms was defective. You could also see a different type of professional negligence claim, where it has to do with the input that was placed into the program and an allegation that there was negligent programming on the front end of the AI product. From that standpoint, we'll see these artificial intelligence producers become parts of the lawsuits on a much more frequent basis as physicians are using it more in their practices.
So Scott touched on the potential for professional negligence and product liability claims. From a professional negligence standpoint, a plaintiff might argue that a healthcare provider owed a duty of care to use AI systems in a safe and competent manner. If a healthcare provider failed to do so and the plaintiff was injured as a result, the plaintiff could potentially recover damages. A product liability claim may arise when a plaintiff is injured by a defective AI system. Generally, we can expect these claims will be aimed at manufacturers of AI systems, but larger healthcare systems may develop and be legally responsible for their own AI-based systems. A breach of contract allegation could arise if a provider fails to use an AI system in accordance with the terms of a medical treatment contract between the provider and the patient. Fraud claims could arise when a provider or healthcare system knowingly or intentionally promotes the capabilities of an AI system that can't meet the promised outcome. For example, the healthcare provider might claim that an AI system is more accurate than has been proven, or that it can be used to diagnose a particular condition outside of its intended purpose. And finally, we can expect to see privacy-based claims from patients who are concerned about their medical information being utilized by AI systems. And I'm going to look at a case later that provides a bit of guidance on this specific topic. Currently, we're unaware of any medical professional negligence lawsuits that involve AI. That said, as AI tools become more deeply integrated into clinical decision making and care delivery, it's reasonable to expect that such claims will start to emerge. While the timing and the contours of the litigation remain uncertain, AI-related negligence, excuse me, allegations are likely inevitable as courts begin to assess how existing malpractice principles apply in AI-assisted care. AI is most likely to intersect with malpractice claims in one of two primary ways. First, if AI recommends a specific action or treatment and the physician either overrides or ignores the suggestion. And second, if a physician follows the prompt or AI software generated guidance and it's later found that the AI was, in fact, not correct. So the quote that you see comes from a journal article published in the May 2023 edition by Neuroradiology. The article was quick to establish that while the medical legal framework for AI in healthcare is in relative flux, the ultimate responsibility for a diagnostic or therapeutic decision will likely remain with the physician, who has to validate the results of the clinical decision support or CDS tool. This sentiment truly serves as an underlying theme for our presentation. Oops, sorry.
I think the first thing is as of today anyway, we really haven't seen a lot of lawsuits where either the failure to use or overuse of AI has been a central component of the cases. And I think part of the reason, especially on the issue of whether there's a failure to use AI, is because it's really not that prevalent yet in most doctors' offices as far as using it to make diagnoses or treatment recommendations. But I think we will see a tipping point. There will be a point where the AI becomes consistent enough, where it becomes effective enough, where it becomes prevalent enough in healthcare providers' offices and in hospitals that the majority of healthcare providers are going to be using it. And when we reach that tipping point, I think that's when we'll see for the first time plaintiffs' attorneys pursuing those theories that the failure to use AI is below the standard of care. I think it's important when we see that happen, though, that from a traditional medical malpractice standpoint, a lot of the same components are going to be there. There's going to be an aspect that the plaintiff's attorney is going to have an expert come in and say that there's been a breach of the standard of care and the failure to use AI with that specific patient or under those specific circumstances. I think, though, it's going to be untraditional in a way that for a plaintiff to win on that theory, that if they can prove that there was a breach by not using an AI product, to prove the second half, I think they've got to prove what AI product or products they say should have been used, what the input would have been into those products from the physician on that specific patient, what the output would have been as far as diagnoses or treatments from that AI product, and in the end, that would have made a difference in the patient's ultimate outcome. So I think it'll be a little more complicated, maybe on the causation aspect, but it will still largely be like a traditional medical malpractice case. We are telling physicians now is you are not able to throw away your skill and your judgment in how you care for a patient. If you are using AI as a tool, it's a tool there to augment your care and treatment of the patient, but it in no way obviates your duty to exercise your own independent skill and your own independent judgment in treating a patient.
Another big legal question surrounding AI is this: is it a product? And I'm going to go briefly into product liability here, but I do want to get through the whole presentation. It may go over a few minutes, and I apologize for that if those of you can't stay. But I'm going to just move ahead. But product liability, from a product liability perspective, claims may focus on an AI developer or vendor alleging design defects, inadequate training, failure to warn, lack of transparency regarding limitations, or post-market failures such as insufficient monitoring and updates. And plaintiffs may argue that AI was unreasonably dangerous as designed or marketed. At the same time, clinicians and healthcare organizations remain exposed under medical professional liability theories. Even when an AI tool is FDA cleared or marketed as a clinical decision support, providers are expected to exercise independent medical judgment and to understand the tool's appropriate use, and limitations and outputs as well. So going forward, it's possible that plaintiffs will plead product liability and other theories. Earlier, we discussed the black box problem and challenges it creates for clinicians when explaining how AI systems function with patients. In the following clip, Scott Salter examines how these same AI systems can create significant challenges.
Having access to the AI products, algorithms, or data sets is something that's going to go back to the AI producer. In that regard, there is a problem in the sense that most AI producers aren't going to want to provide that information. It may take getting in touch with their legal counsel to be able to do that. But within that, one of the big problems is still going to be that these AI products, as far as their decision making, are not transparent. They're very opaque. There are many layers to the information they have and how they learn. So even if you can determine the data sets that originally went in, even if you can determine the algorithms that the AI product is originally based on, as it learns and the layers that are there, it's going to make it very, very difficult to understand or to recreate the reasoning that the AI product used in making any recommendations to the physician.
The American Law Institute, known as ALI, publishes restatements, and these are concise yet thorough summations of specific laws of all states and sometimes suggests how model law should be. It provides commentary, examples, and guidance on how to apply rules of law to certain legal questions. While restatements are not binding, they are given great weight by courts and attorneys as persuasive points and definitions for legal determinations. In 2024, the ALI updated the restatement that defined standard of care as it would apply to medical malpractice claims. For decades, the standard of care in medical malpractice cases focused on what other prudent physicians would do in similar circumstances. While customary medical care is still a factor, the updated language is standard of reasonable medical care and incorporates both patient-centered and evidence-based considerations, including the availability of more contemporary tools and treatments. The new language could be used in multiple ways to approach a medical problem or diagnosis, and providers should be aware of using specific independent and independent judgment, provided it is reasonable, even if other providers would do it differently. The Alley's revised legal treatise now includes, as relevant, the state of medical knowledge and treatment options available at the time, as well as resources available to the provider in the particular location or practice setting. There may be a scenario where customary practice has not caught up with the changing standards and technology diagnostics or treatment to the physician, including AI. Each state may choose whether it will incorporate portions of the revised language into its current statutory framework governing medical negligence cases. For some time, we will likely continue to see standard focused on prevailing customary care. However, this updated view allows judges, juries to think differently. What would be reasonable for this patient given the clinical course available versus what most doctors are doing? This revised interpretation opens the door for consideration of available AI interventions to be within the standard of care, even when most physicians may not be utilizing them to the same degree or at all. Conversely, emphasis on the individual patient and limited resources that may have been available to the provider may possibly allow for broader defense. While this modernized standard arguably favors a physician defendant, it is conceivable that a juror may find negligence when a physician chooses not to use available AI. So I'm very mindful that I'm over the hour. Am I okay to keep going here? I apologize. This is a longer presentation than was previously done. And you guys are the first test case. So I do apologize. Danielle, am I okay to keep
Yeah,
continue?
how much more time do you think you need, Anne-Marie?
Probably 10 minutes.
Okay, why don't you keep going and we'll keep recording, and then if people have to
Okay.
drop off, the recording will be on our YouTube.
Yeah, and I apologize up front. I'm at 59 minutes on my own clock, so all right, here we go. As discussed, there has not yet been a medical malpractice lawsuit that's exclusively centered on AI. Nevertheless, there are already numerous cases involving AI in the healthcare industry, along with many others that, while not directly focused on the clinical decision making of AI, offer meaningful insight into how courts may approach related disputes. In the following slides, I'm going to go over several of the cases that illustrate the emerging legal themes. AI chatbots have created a new wave of lawsuits in the healthcare space. In several high-profile cases, users interacted extensively with AI chatbots before experiencing severe harm, including suicide. Other reported cases involved users who were allegedly manipulated or influenced to the point of eviction, mental health crises, or financial ruin. In these cases, vulnerable users, sometimes minors, are alleged to have developed a high degree of trust and emotional reliance on the chatbot, gradually disengaging from real-world relationships and support systems. Users reportedly shared sensitive thoughts with the chatbot and received continuous, affirming responses available at all hours of the day and night. Plaintiffs' family members have brought a range of legal claims following these interactions, several of which are outlined on this slide. Um, and I'm going to discuss the emerging use of these chatbots in healthcare in a bit. So I'm going to start with a case that actually does not involve AI, but it could give us some idea of where the cases involving AI are headed. The allegation here is following the plaintiff's gallbladder surgery, he was supposed to receive continuous pulse oximetry due to his sleep apnea. The physician entered an order into Cerner's EMR system, expecting immediate monitoring. However, due to the software design, the monitoring was delayed until 10 a.m. the next day. The system defaulted to a start time of the order to the time the doctor opened the entry when the order was submitted. So there was obviously a discrepancy there. And this field was difficult for physicians or clinicians to modify. The unsigned orders list required physicians to scroll through multiple screens to navigate a stacked format to see critical details, leading the doctor to inadvertently overlook the incorrect start time. The plaintiff was found unresponsive in respiratory distress, which led to hypoxia and permanent brain damage. The plaintiff sued Cerner Health Services in a product liability case, alleging the defective design in Cerner's medical order entry software led to the delayed pulse oximetry monitoring. The trial court granted Cerner's motion for summary judgment, but a appellate court vacated that summary judgment ruling, and stated that a jury could reasonably find the software defects were unreasonably dangerous and failed to meet industry standards. Crucially, the court rejected the idea that the doctor's human error automatically absolved the software company of liability. While this case involved a traditional EHR system rather than an AI, it establishes a legal framework that could apply to AI-driven medical tools. The decision reinforces the shift toward treating medical software as a tangible product, subject subject to product liability and negligence claims. It also suggests that if AI's interface or behind-the-scenes logic leads a doctor to make a mistake, the developer can then be held liable for negligent design. Next, I'm going to look at a case involving AI and health insurance that could provide a glimpse. And this case is and alleges that a health insurance carrier in California violated the law by failing to provide individualized physician reviews for insurance claims. Plaintiffs claim that the insurer used AI to systematically review and deny claims in batches, sometimes involving thousands of claims without individual physician oversight. The automated AI system led to mass denials of payment for healthcare services, which plaintiffs argue were done without proper review, causing lack of coverage and unexpected medical bills for insured patients. The complaint highlights that claims were automatically denied by AI and then rubber stamped by physicians without any actual review of patients' files. Plaintiffs portrayed the insurer as using AI as a cost-cutting and time-saving measure, implying a neglect of duty and a preference for efficiency over proper healthcare management. So the takeaway, the case suggests that Using AI in this manner might become a frequent issue in legal challenges, with plaintiffs accusing defendants of replacing necessary human roles with AI to save costs, often at the expense of service quality and compliance. It's worth noting that the causes of action in the case are not based in negligence or medical malpractice law. Rather, they're centered on contract law and the California unfair competition law. Okay, so I'm going to briefly touch on bias. Earlier, I highlighted the importance of data and data sets for the operation and training of AI systems. Large data sets are only part of the proverbial equation here. To ensure AI systems function appropriately for all individuals, steps need to be taken to ensure that the systematic errors or distortions in the data set don't result in unfair, inaccurate, or unequal outcomes. For example, and if an AI system aimed at detecting skin cancer is only trained on images from individuals with a light skin tone, it will not function as intended for all patients. Biased data sets can inadvertently harm patients and expose providers to regulatory risk. In terms of legal liability, a healthcare provider will generally not be responsible for the shortcomings of a defective product that does not do what it's intended. However, a healthcare facility or provider may be held accountable for clinical decision making and subsequent results when relying on a faulty AI algorithm. In 2019, a landmark study published by the Science Journal focused on discriminatorial flawed data underlying an AI algorithm. The racially biased and inaccurate data created a skewed perspective of the acuity level of hospital patients. A hospital algorithm applied millions, excuse me, a hospital algorithm applied to millions yearly was found to be assigning the same level of risk to black patients as to white patients. The problem was that the black patients were actually sicker than the white patients at the time, putting them at risk for delayed or insufficient care interventions. Why did the algorithm inaccurately assign these levels of acuity, not giving enough risk scores to black patients? Well, the AI was using past health costs to predict and respond to healthcare needs based on acuity of condition. Overall, unequal access for black patients um, meant that less money was spent on their healthcare needs. Not necessarily that those needs weren't didn't exist. Therefore, when health needs were based on health costs, it led to erroneous deduction that less money spent on hospitalizations for black patients meant that the black patients must not be as sick. The study found that removing the disparity would increase the percentage of black patients receiving the healthcare assistance that they needed by a staggering 30%. The good news, per the study, label biases are fixable. So we just need to be careful about and purposeful about the data that's fueling the algorithms. To ensure that AI systems in healthcare properly serve all patients, OCR took proactive steps to address the risk of bias in AI data sets. Section 1557 of the Affordable Care Act prohibits discrimination in a healthcare program or activity that receives federal financial assistance on the basis of race, color, national origin, sex, age, or disability. In 2024, OCR's final rule set forth two new requirements of covered entities to eliminate discriminatory harm caused by AI in healthcare products. Strict liability was not imposed through that Section 1557, but responsibility for managing discriminatory risk was placed on the AI users, not the entities that developed the system. Related to decision-making tools, what OCR originally referred to as clinical algorithms were updated to patient care decision support tools. Importantly, this definition includes both at the individual clinical level as well as administrative decisions based on groups of patients with shared characteristics, including risk adjustment and medical necessity. OCR specifically noted that widespread use of vast automated systems, decision systems, and AI, and confirmed AI is included in the definition of a patient care decision support tool, which could result in prohibited discrimination. The final rule contains two minimum legal requirements for covered entities. Review for potential discrimination within a CDS tool for using protected class information as a variable, and two, taking reasonable steps to mitigate the discrimination. Okay, we're in the last hall here. The department, we're going to discuss HIPAA real briefly. The Department of Health and Human Services oversees HIPAA, as you know. And although HIPAA was enacted long before the advent of modern artificial intelligence, the foundational principles, privacy, security, and appropriate use and disclosure of protected health information, believe it or not, apply fully to AI-enabled technologies. So any AI system that creates, accesses, transmits, or stores protected health information is subject to HIPAA's requirements. And that's the bottom line here. So I've discussed the importance of disclosure and transparency when patients are exposed to AI technologies. But an important follow-up question is whether a practice must obtain a HIPAA authorization before sharing patient information with an AI system. In most cases, a HIPAA authorization is not required when an AI system uses PHI for treatment, payment, or operations, commonly referred to as TPO exceptions. A critical prerequisite, however, is ensuring that the AI vendor is operating with a business associate agreement. And that's really the crux here. The actual HIPAA forms aren't as necessary as ensuring that when you enter into an agreement that you have a signed BAA that goes through all of the necessary requirements. So I'm going to look briefly at a case that demonstrates the importance of proper de-identification of data, and then we're coming up to the end. Although HIPAA established principles clearly apply to AI systems, HHS has acknowledged that emerging technologies introduce new and evolving risks that warrant additional safeguards to protect patient data. In January of 2025, HHS published a proposed update to the HIPAA rule, which basically addresses the response to increasing frequency and sophistication of cyber attacks, as well as significant changes to the healthcare technology landscape. Most notably, the proposed rule would eliminate or narrow the distinction between addressable or required safeguards. Under the approach, covered entities and business associates would no longer be able to just rely on informal, risk-based justifications for declining to implement certain security measures. Safeguards that were previously considered addressable, such as multi-factor auth excuse me, routine vulnerable scanning and penetration testing would become mandatory under the final rule. So I'm going to review a few key HIPAA risk reduction strategies here. First, while most AI-supported operational uses may fall under the treatment, payment, or healthcare operations authorization, it's still required when data use extends beyond those permitted purposes. When in doubt, obtain clear documented patient authorization. Review your BAAs, understand exactly how the vendor will potentially process, store, and use PHI, including any model training, subcontractors, or secondary data uses. During medical encounters, personal circumstances are often discussed, such as who lives in the home, current work and school environment, or individual stressors. It is often unclear if, how, or when the information gathered by an AI program may be shared with an outside entity, including a state or federal government. When possible, use AI systems designed to de-identify or make anonymous patient data. Proper de-identification materially reduces regulatory exposure and breach risk, but practices should verify the vendor's methodology and safeguards. Remind staff that AI integration does not relax HIPAA obligations. Systems and workflows should limit PHI access to only what is reasonably necessary. AI chatbots have moved from a quick online customer service solution to an active global player in addressing um, it, all types of personal consumer inquiries. That is no small issue. In 2024, a misinformation tracking poll found that two-thirds of adults use AI, with one-third doing so weekly. 1 in 6 adults use AI chatbots monthly for health advice, rising to 1 in 4 for those under 30. This influential leap by chatbots emphasizes new safety and ethical priorities into the crossover to AI and healthcare. Transparency, accountability, fairness, and human oversight, and how AI chatbot vendors must apply the goals to guide responsible and safe use have become critical points of focus. Yeah, so just briefly, we know that it's significant, and how you address it. The Emergency Care Research, or ECRI, one of the country's most respected patient safety organizations, publishes a yearly list of health technology hazards, and leading the list in 2025 was AI-enabled healthcare technologies. Not surprising, and that includes the use of chatbots. A lawsuit filed in 2025 against OpenAI alleged that a 16-year-old from California hung himself at home after a months-long interaction with OpenAI's ChatGPT. The lawsuit alleged that OpenAI bypassed critical safety features needed to pick up on dangerous comments by the teen. The chatbot encouraged the minor to end his life, dissuaded him from discussing his thoughts with family. It's kind of crazy, right? And helped plan the detailed steps of the suicide. The complaint states that the OpenAI system tracked but never tried to stop a predictable pattern of teenager's mental decline, and in fact offered to draft his suicide note. Despite hundreds of real-time opportunities to discourage the path of self-harm or otherwise intervene, the chatbot was never triggered to attempt communication with the boy's parents or crisis resources. In this case, was not against a healthcare provider and centered on deceptive business practices, negligence, and design defect. However, this fact pattern could easily become a medical malpractice claim if a healthcare entity or professionals were utilizing an unchecked, unvalidated AI bot for mental health therapy. It's kind of scary stuff. Misinformation is unintentionally misleading or inaccurate. Excuse me. Um, Basically, you can read here, there are significant organizations that are addressing this, and it's just more to come here. Physician practices should stay diligent in learning where patients are getting their information that informs their opinions and what resources they have available to them for physical and mental health. And I'm just going to play a clip from Scott, go through a few more issues, and then we'll be done.
When a patient comes in with misinformation from artificial intelligence, it's going to be important for the doctor to spend time with that patient. They've probably turned to the artificial intelligence, at least partly because they feel they have not gotten the time or the answers they want from their doctor. And so it's going to be important to sit down and spend the time, listen to them, talk to them, and explain why for them with their specific conditions, with their medications, with their past medical histories, with all of those things, why the information they got from the artificial intelligence product really doesn't apply to them, why that's misinformation from them. And then really to give that person some affirmation of what you are going to do and what needs to be done for them.
So I know I've quickly gone from AI into the final steps here, and I apologize for that. Um, I'm not going to go through the last case. We're at 20 minutes after. But I just wanted to thank you all for your time here. Um, and I appreciate that you stayed with me here. And just want to thank you for your time today. I hope
A
it was
physician
meaningful, and I'm very, very sorry that I rushed at the end. This was a 2-hour program, and we cut it down to 1 hour. And you guys were the test case, and so I just want to thank you. And you'll get all of the slides, and I'm happy to entertain any questions with you on a one-to-one basis. Come back with a better, cleaner version. And I just want to thank you all. And
I think as
that's
we
it.
move forward.
Thank you, everyone, and thank you, Anne Marie. I'm going to stop the recording.